What we see in terms and conditions of the standard form contracts is that banks will act on the instructions that they receive that appear to originate from the customer, and secondly, that the customer cannot reverse or cancel or withdraw any instructions given, even if it is a repeat payment or into the wrong account. And then further to support that, banks cannot be held liable for a customer's own negligence. Despite these standard form terms and conditions in the contracts for the use of these facilities, banks do try and assist as far as possible. But if a client is faced with litigation, it doesn't produce consistent results, and there are a number of unresolved issues. What you will see after this discussion is that the risk of loss lies with the customer or the user of the service. The procedure to follow if there was a mistake is to notify the recipient of the money that it is a mistaken payment, and then on an urgent basis to apply for an interdict so that the money cannot be taken out of the account or used. And then you have to apply for a court order for the money to be returned based on undue enrichment. Generally, the bank's attitude is that they received a valid instruction and they followed orders, and they are not liable for your negligence. And therefore, if there is a dispute, you must sort it out with the recipient of the money. But it is when we have a look at the cases where the real problems with this become clearer. The first case that we had was Take and Save, where Standard Bank claimed 10 million rand from Take and Save, as well as 2 sureties for a debt. A manseur was one of the sureties, and he was also the sole owner of the Take and Save stores. What he did was he deposited checks and immediately transferred an amount to a creditor supplier. The checks bounced, and Mansur told the bank to reverse the payments made to the creditor. The bank did, and the supplier objected, and therefore the bank stopped the reversal. The main argument was about the bank not adhering to a client's instructions. And in the case, evidence of the interbank agreements that prevent the reversal of EFTs was led, and in the process the court made an obiter passing comment that you cannot retransfer or reverse a transfer without a beneficiary's consent. Now, this was criticized because in most cases the transferor of funds has a legitimate reason for a reversal. That is because the beneficiary details are incorrect, the bank details are incorrect, etc., etc. They are not entitled to the money, and the law cannot expect from a beneficiary or recipient of this money to give consent every single time. This was followed shortly thereafter by the Nissen case. Now, Nissen was an F&B client and instructed them to make payments to certain creditors. One of those creditors was TSW, who Nissen told F&B to pay 12.7 million rand. But Nissen gave F&B the wrong bank account details, and the money was obviously not paid to TSW. Instead, it went into a close corporations account. Now, to just add to the spice of this particular set of facts, the transfer took place on the 31st of December 2002. The close corporation, who received a 12.7 million rand New Year's gift, used the funds. And on the 20th of January 2003, Nissen realized the mistake and demanded the money back. The close corporation said, all right, we will pay you back, but we are going to retain the interest as well as charge you a holding fee of 4%. Nissen didn't like this, and they got a court order to freeze the close corporation's bank account, and as a reaction, the owner then sent his business into voluntary sequestration. When the account was frozen, only 10 million rand was left. The trustees of the insolvent business argued that the amount formed part of the insolvent estate and that Nissen was a creditor who had to stand in line and wait for what was left to be divided between the creditors. And the question that the court had a look at was, did Nissen remain the owner if it had transferred the money mistakenly? The court looked at take and save and found it to be incorrect. In other words, the court held that you can reverse an EFT without beneficiary consent. And the reasoning the court followed was that the close corporation was not entitled to the funds. They did use it, which constitutes theft. Soneker severely criticized this decision as incorrect in law and based on enrichment action common law. But in Pestana versus Nedbank, which went through all three levels of court, basically the facts were on the 4th of February 2004, Pestana 1 owed SARS 340 million rand. And he had an account with Nedbank. In that account, he had 450,000 rand, which he transferred to a Pestana number 2, who was also a client at Nedbank. Now, at about the same time, SARS had sent what they call a Section 99 notice to Nedbank to pay over any money in the bank account held by Pestana number 1. Nedbank realized their mistake and reversed the payment to Pestana number 2 and paid the 450,000 rand to SARS in terms of the court order and Section 99. Pestana number 2 argued that Nedbank had acted without authority when it reversed the credit and that they needed Pestana number 2's consent to reverse the payment. In the lower court, they said no. The bank is allowed to reverse because the SARS order came first, and if the bank had complied, there would not have been any money available to transfer to Pestana number 2, and therefore they could not give effect to the transfer to Pestana number 2. This went on appeal to the High Court, where it was held that the SARS claim in terms of Section 99 did not freeze a person's account, and it did not automatically transfer funds to SARS. Once the bank had made an unconditional decision to pay Pestana number 2, it could not reverse that decision without Pestana number 2's permission. All right, these decisions have been criticized by various parties in South African law. Professor Schultz criticizes this decision that an EFT is an unconditional payment and cannot be reversed by a bank if it is aware that the recipient is not entitled to the amount. He said that it's wrong because it is part of the banker-client agreement that a transfer is conditional on the point that the recipient is entitled to the amount. Therefore, you need to distinguish between valid transfers and invalid transfers. If you look at these examples, in Take and Save, it was a valid transfer. In Pestana and in Nissen, it was an invalid transfer. But, as he points out, we still have no clarity or guidance to decide which are valid or invalid transfers. Professor Sonekas disagrees with Schultz and says it is not a conditional payment. In his criticism of the Pestana decisions, Professor Sonekas tells us that there are 2 points that you need to consider. The first is the bank's capacity to unilaterally reverse credits, and secondly, the effect of the Section 99 order from SARS. According to him, the Section 99 order from SARS only relates to assets held by the bank. In other words, if the bank doesn't hold any assets, the bank does not have a duty to look for and collect assets on behalf of SARS. Therefore, if money was in the account or money comes into the account, they need to pay that money over to SARS. If there is nothing there, there is nothing that needs to be paid to SARS. And therefore, the bank account holder managed to move his assets before SARS could get hold of it. And it was not the bank's responsibility to look at the legitimacy of the transfer. On the bank's capacity to reverse credits, he says that when the request is given to the bank to transfer money, the money was available. When they took the decision to pay, it was an unconditional decision. There was consensus. The conditional payments are for things like checks, where we have to check signatures and if the amount is available. None of these are applicable where you're dealing with EFT. Basically, the bank just has to check that funds are available, and if they receive the instruction, they are obliged to carry it out. Now, the decision to pay was coupled to a decision to accept payment into the second account, and you therefore have no capacity to reverse it. It is an unconditional payment, and it does not change when the bank later became aware of the Section 99 notice. The fact that it was not communicated in time before transfer was made means that the bank is at fault, but it does not change the legal position around the payment to Pistana number 2. What he says is that it is a mistake that cannot vitiate a completed bilateral act of payment. Once the bank has debited and credited, it is a completed juristic act independent of any underlying justa causa. Alright, in light of this, ladies and gentlemen, there are other authors who tell us that in light of international trends, a strong argument can be made out that there is a duty on banks to match account numbers and the names of beneficiaries. Since the Pistana case, we've had 2 further significant cases on EFTs. The next one was Lombard versus ABSA and one other bank, where the accountant of Lombard's insurance took a large sum of money and used it to pay off various credit and home loan accounts that she had with other banks. Even though the money was stolen, the court in this case held that they could not be reversed. Okay, so in direct contrast to your earlier decision of Nissen. And then that was followed on by the Dumas Estate Whitehead versus Dumas case, where Whitehead was running a fraudulent Ponzi scheme. He had organized that Dumas pay him a certain amount as an investor into this scheme, but as this transaction was going through, Whitehead was arrested for his role, and Dumas wanted his money back from the insolvent estate. The court decided it could not be reversed in line with that of the Nissen case. As we can see here, ladies and gentlemen, very uncertain, no clear legal guidelines on when you can and cannot reverse an EFT.